The Supreme Court just shut down a loophole that's been protecting police shootings for years. 9 justices, 0 disagreement, and a complete reset of how courts must judge whether an officer's use of deadly force was legal or a violation of your constitutional rights. This is Barnes versus Felix, decided unanimously on May 15, 2025. And if you carry a gun legally, if you've ever been pulled over, if you've ever wondered what happens when a police encounter goes catastrophically wrong, this ruling changes everything about how justice gets served or denied in those moments. This is about your Fourth Amendment rights during traffic stops and why the highest court in America just told lower courts they can no longer put on blinders and pretend the 2 seconds before a shooting exist in a vacuum, disconnected from everything that led to that trigger pull. If you care about your constitutional rights, if you understand that legal precedent determines whether you get justice or a cover-up when something goes wrong, subscribe to this channel right now. Hit that button and turn on notifications because what I'm breaking down today is barely getting covered by mainstream media, but it affects millions of Americans every single day. This isn't theoretical legal analysis. This is about whether courts will look at the whole truth or just the convenient parts when an officer uses deadly force. Don't miss these updates. Subscribe now. Here's what just happened and why it matters so fundamentally that every single Supreme Court justice agreed on it. When a police officer shoots someone, that's legally considered a seizure under the Fourth Amendment. The Constitution says seizures must be reasonable. The question is, what are courts allowed to look at when deciding if that seizure was reasonable or unconstitutional? Can they only examine the split second when the trigger was pulled? Or can they look at everything that happened before that moment, every decision the officer made, every command given, every action that created the circumstances leading to deadly force? For years, 4 federal circuit courts, including the Fifth Circuit covering Texas, Louisiana, and Mississippi, used something called the moment of threat rule. This rule said judges could only look at the precise instant when the officer felt threatened. Everything before that moment was legally off limits. Didn't matter if the officer created the danger himself. Didn't matter if the officer made decisions that guaranteed violence would be the only outcome. Only the final 2 seconds counted in court. Let me explain why that's absolutely insane. And I'll use the actual facts from Barnes versus Felix to show you how this played out in real life. On April 28, 2016, a man named Ashtian Barnes was driving on a highway outside Houston, Texas. A constable named Roberto Felix got a radio alert about outstanding toll violations linked to Barnes's license plate. Felix pulled him over. Routine traffic stop, nothing extraordinary. Felix walked up to the car and asked for license and insurance. Barnes said he didn't have his license on him and explained the car was a rental in his girlfriend's name. Barnes started looking around for paperwork. Felix told him to stop digging around in the car. Then Felix said he smelled marijuana. Barnes mentioned maybe his ID was in the trunk. Felix told him to pop the trunk from inside the car. Barnes did, and he also turned the ignition back on. Now here's where everything goes off the rails. Felix opened the driver's door and pulled his gun. Barnes started driving away. And this is the critical part, the part that should matter in any honest evaluation of what happened next. Felix jumped onto the door of the moving car. He's literally hanging on the outside of a vehicle that's now in motion. He yelled twice, "Don't fucking move!" Then, with his head above the roof so he couldn't even see inside the car, he fired 2 shots into the vehicle. Barnes was hit and died, but he managed to stop the car first. The whole thing from the car moving to it stopping took 5 seconds. The time from Felix jumping on the car to firing the first shot? 2 seconds. Barnes's mother sued Felix under federal civil rights law, arguing he used excessive force and violated her son's Fourth Amendment rights. And here's what happened in the lower courts. Here's where the system failed so catastrophically that it took a unanimous Supreme Court to fix it. Both the District Court and the Fifth Circuit Court of Appeals said they could only look at those final 2 seconds when Felix was hanging on the moving car. They said at that moment a reasonable officer would fear for his life, so the shooting was justified. Everything before that, including Felix's decision to jump on a moving car, was legally irrelevant under the moment of threat rule. Think about how insane that standard is. The officer created the dangerous situation by jumping on the car. But under the old rule, the court couldn't even consider that fact when judging whether the shooting was reasonable. It's like if I picked a fight with you, you defended yourself, and then I shot you and claimed self-defense. But the jury wasn't allowed to hear that I started the fight. That's essentially what the moment of threat rule allowed. It gave officers a free pass to create danger and then use deadly force to escape the danger they created, and courts were required to ignore the first part and only judge the second part. Barnes's mother appealed to the Supreme Court. And here's what the court said, unanimously, without a single dissenting voice. Justice Elena Kagan wrote the opinion and made it crystal clear. The Fourth Amendment requires courts to look at the totality of the circumstances, not just one moment, not just 2 seconds, everything relevant that happened during the encounter. The court said, and I'm telling you their exact reasoning here, a court deciding a use of force case cannot review the totality of the circumstances if it is put on chronological blinders. Chronological blinders. That's what the Fifth Circuit and 3 other federal circuits had been wearing for years. They were deliberately ignoring context, ignoring cause and effect, ignoring the basic question of whether an officer's own actions made violence inevitable. The Supreme Court pointed to another case, Plumhoff versus Rickard, to explain this principle. In that case, a driver led police on a dangerous 5-minute car chase at over 100 miles per hour. When officers finally shot him, someone argued the shooting was unjustified because the chase was technically over at that exact moment. But the Supreme Court said no. You have to look at everything. The 5 minutes of reckless driving, the danger to the public, the totality of what happened. All of it matters in understanding whether the shooting was reasonable at the final moment. If you're starting to see how this could affect you during a traffic stop, if you're realizing that the standard for judging police use of force just got a lot more honest, then subscribe right now because the next video breaks down the exact words to say when police ask if you're carrying a gun. These aren't just random phrases. They're legally tested responses that protect your rights without escalating the situation. Hit subscribe and turn on notifications so you don't miss it, because that information could save you from a felony charge or something far worse. Don't wait until you're in handcuffs to start learning your rights. Here's why the Barnes versus Felix decision matters so much, especially if you're a gun owner who carries legally. Every time you get pulled over while armed, you're in a Fourth Amendment encounter. If something goes wrong, if an officer uses force against you, this ruling determines how that incident gets judged in court. Under the old moment of threat rule in those 4 circuits, an officer could do all kinds of unreasonable things leading up to using force, but as long as he felt threatened at the final instant, he was protected. Courts would ignore his contradictory commands, his failure to de-escalate, his decision to put himself in a position where violence became the only option. None of that mattered under the old standard. Not anymore. Now, courts must look at whether the officer's own actions created the danger. Did the officer give commands that made the situation more dangerous? Did the officer fail to use de-escalation techniques that could have prevented the need for force? Did the officer put himself in a position where he'd have no choice but to use deadly force? All of that is now fair game in court. Let me give you a hypothetical example to make this concrete and real. Let's say you're legally carrying concealed. You get pulled over for a minor traffic violation, and you properly notify the officer that you have a permit and a firearm, exactly as you're supposed to do. The officer tells you to reach for your wallet to get your license. As you reach, the officer suddenly yells, "Gun!" and shoots you. Under the old moment of threat rule in those 4 circuits, a court might only look at the split second when your hand moved toward where the gun was holstered. At that moment, was the officer in fear? Yes, shooting justified, case closed. But under the new standard after Barnes versus Felix, the court must look at the whole thing. Did the officer create the danger by ordering you to reach near your gun? Did the officer fail to first secure the weapon, or have you step out of the vehicle? Was the officer's command itself unreasonable given that he knew you were armed? All of these earlier circumstances now matter in judging whether the force was reasonable. That's a massive shift in how these cases get evaluated. The decision also includes something interesting in Justice Brett Kavanaugh's concurring opinion. He was joined by Justices Clarence Thomas, Samuel Alito, and Amy Coney Barrett, the court's conservative wing, and he spent 6 pages talking about how dangerous traffic stops are for police officers, and he's absolutely right about that. Officers do get killed during traffic stops. It's one of the most dangerous things they do on the job. But here's what's critically important. Even after acknowledging all that danger, even after explaining how difficult these split-second decisions are, Justice Kavanaugh still joined the unanimous opinion, saying courts must look at everything, not just the final moment. That tells you something fundamental. This isn't about being anti-police or pro-police. This is about the Constitution. The Fourth Amendment doesn't say the government can seize you, which includes shooting you, as long as an officer feels scared at the final second. It says seizures must be reasonable, and you cannot judge reasonableness by putting blinders on and ignoring everything that led to that moment. 73% of people watching right now aren't subscribed to this channel. Don't be part of that statistic. Join the community of informed Americans who get these critical legal updates first. Click subscribe because the legal landscape is changing fast, and you need to stay ahead of it. This isn't just content. This is your constitutional rights we're talking about. Hit that button now. Now, let's talk about what this means going forward, because the Barnes decision has 2 levels of impact: what happens in this specific case and what happens in every future case across America. The Supreme Court sent the Barnes case back to the lower courts and told them to reevaluate Officer Felix's shooting using the full timeline, not just the final 2 seconds. We don't know yet what will happen to Felix. The Supreme Court didn't say the shooting was definitely unreasonable or definitely constitutional. They just said the lower courts used the wrong test, the wrong standard for judgment. So the case will be analyzed again, this time looking at everything, including whether Felix should have jumped on that moving car in the first place, whether his actions created the danger that he then used as justification for deadly force. But the bigger impact is on every future case involving police use of force. Police departments across the country are going to have to retrain officers on when and how force can be used, because they can no longer rely on the moment of threat rule to shield unreasonable decisions. Prosecutors reviewing police shootings will have to consider the full encounter, what the officer did before the shooting, not just what the officer claimed to fear during the shooting. And defense attorneys representing people shot by police now have a unanimous Supreme Court decision saying the totality of circumstances matters. This levels the playing field in a way it hasn't been in years. It restores honesty to the process of judging whether force was justified or whether it was a constitutional violation that deserves accountability. Here's something else nobody's talking about, and it's potentially huge for future cases. The Supreme Court specifically did not address one issue in Barnes, and it's a critical question. They didn't decide whether an officer loses the right to use force if he created the danger in the first place. They left that question for another day. Justice Kagan wrote that this issue wasn't properly before them because the lower courts never addressed it due to their narrow time focus on just the final moment. So that question is still out there, unresolved. Can an officer intentionally or recklessly create a dangerous situation and then use deadly force to get out of it? We don't have a clear answer yet from the Supreme Court, but the fact that they mentioned it means it's on their radar. It's coming. For gun owners, this unresolved question is especially relevant. Imagine an officer sees you have a holstered gun during a traffic stop. He gets nervous and starts making erratic, contradictory commands. Put your hands up. No, wait, show me your license. No, hands on the wheel. Now reach for your ID. You're trying to comply, but the commands are contradictory and confusing, and you're trying not to get shot. If that officer then shoots you because he interprets your confused movements as threatening, should he be protected? Under the Barnes ruling, courts now must look at whether his own contradictory commands created the confusion that led to the shooting. That's progress. That's a more honest evaluation. But the question of whether creating danger eliminates the justification for using force, that's still pending. Here's what you need to understand clearly. This ruling doesn't mean officers can't use force. It doesn't mean every police shooting is now going to be found unconstitutional. What it means is that courts have to be honest about the full picture. If an officer acts reasonably throughout the encounter and is forced to use deadly force because of an actual threat he didn't create, this ruling doesn't change that outcome. Reasonable force based on a real threat is still allowed. The Fourth Amendment has always permitted that. What this ruling stops is officers hiding behind a technicality. They can't act unreasonably for 2 minutes and then claim the final 2 seconds justify everything. Context matters, cause and effect matter. Your constitutional rights don't disappear because a court agrees to ignore half the evidence. This information could literally change everything about how police encounters are judged going forward. Subscribe to this channel right now because the next video breaks down exactly what to do, step by step, when you're carrying and you get pulled over. The wrong words can get you killed. The right words can save your life. I'll show you exactly what to say and what never to say. Don't miss it. Hit that subscribe button and turn on notifications now. Let me bring this home with the bottom line, because this matters beyond the legal technicalities and the case citations. The Barnes versus Felix decision reaffirms that the Fourth Amendment means something real and enforceable. When the government seizes you, whether through arrest or through deadly force, that seizure must be objectively reasonable based on the totality of the circumstances, not a cherry-picked moment, not a convenient 2-second window that ignores everything that came before. Everything. The whole truth. This matters for gun owners because we're often the ones in these encounters. We're the ones who get pulled over and have to navigate the complicated and sometimes terrifying process of informing officers we're armed. We're the ones who need courts to look at the full picture if something goes wrong. Did we act lawfully? Did the officer act reasonably? Or did someone's poor decisions create an unnecessary tragedy that could have been avoided? Those questions can only be answered honestly by looking at everything that happened, not just the final moment when the trigger was pulled. The Supreme Court got this one right, 9-0, unanimous. And that should tell you this isn't a political decision driven by ideology or partisanship. This is a constitutional decision. Your Fourth Amendment rights just got stronger. Not because courts will automatically side against police in every case, but because courts will finally have to look at all the facts before making a decision. They can't ignore the officer's actions leading up to the use of force. They can't pretend that 2 seconds exist in isolation from the 2 minutes that preceded them. That's constitutional honesty, and it's been missing from too many courtrooms for too many years. If you learned something today, if this opened your eyes to a major shift in how your rights are protected, here's what I need you to do. Hit that subscribe button and turn on notifications. These legal changes happen fast, and most Americans don't find out about them until it's too late, until they're already in a situation where knowing this information could have changed the outcome. The next video in this series covers the 5 words that can protect you when an officer asks about your gun. It's based on actual case law, it works, and it could keep you out of jail or worse, but you'll only see it if you're subscribed. Don't gamble with your rights. Subscribe now. And one more thing, share this video with every gun owner you know. Share it with your family, your friends, your shooting buddies, anyone who carries legally and needs to understand how the system works when things go wrong. Constitutional rights only matter if people know about them. The Barnes versus Felix decision is barely getting covered by mainstream media outlets, but it affects millions of Americans every single day. Get the word out. Make sure people know that the Supreme Court just told lower courts they can't ignore context anymore. Make sure people know their Fourth Amendment rights just got real enforcement power again. Remember, this is educational content about your constitutional rights. It's not legal advice for your specific situation. If you're involved in a police encounter or facing legal charges, get a qualified attorney in your jurisdiction immediately. But knowing your rights before you need them, that's not optional. That's essential. The Supreme Court just reminded the government that the Constitution still applies even in those final split seconds of a police encounter. They reminded lower courts that honesty matters, that context matters, that you can't judge whether force was reasonable by ignoring everything that made the force necessary in the first place. 9 justices, 0 disagreement, and a major win for the Fourth Amendment. Now you know what happened and why it matters. Stay informed, stay safe, and never forget that your rights only exist if you know them, and you're willing to assert them. The law just shifted in your favor. Don't waste it.